Good afternoon, everybody. I want to welcome everybody to the Ethics Commission's Dakota Dilemmas, a historical exploration of ethical conflicts. Um, Thank you, everybody, for being here this afternoon. We hope that this next hour and a half together is informative and that you learn lots of new things about the historical exploration and the historical perspective of ethical conflicts. My name is Rebecca Binstock, and I have the privilege to serve as the Executive Director of the North Dakota Ethics Commission. And with me today to walk us through this exploration is going to be Logan Carpenter. Mr. Carpenter serves as the General Counsel for the Ethics Commission. Mr. Carpenter graduated from the University of North Dakota School of Law in 2020. After law school, he served as a judicial law clerk to the Honorable Justice Gerald Vandewaal at the North Dakota Supreme Court. He then continued his career as a judicial law clerk to the Honorable Claire Hochhalter, Magistrate Judge for the District of North Dakota. After he was there, he joined the Ethics Commission last year, and we are excited to have him. So again, I want to thank everybody for being here today and joining us today for Dakota Dilemmas, a historical exploration of ethical conflicts. So we are here today to share with all of you this historical perspective because of a comment or a thought that we commonly hear. Many folks think ethics laws and conflict of interest laws in North Dakota started in 2018 with the creation of the Ethics Commission. In fact, this history goes back a very long time to the time of Dakota Territory before we even had statehood. It's taken many forms over the last 160 years, and today we hope to share that intriguing history with all of you. This webinar today is the Commission's first in a series we've entitled Dakota Dilemmas. Both the Ethics Commission and the North Dakota Legislative Assembly have recognized this need for education about the Commission, what it does, and what its mission is. So we decided there is no better place to start than the beginning, with a historical review of ethics laws. So please feel free to ask your questions in the chat as we go along today. You're welcome to drop those in there. And then what we'll do is, as we get to our question and answer portion at the end, we will then ask those questions and we'll ask Logan. And if I need to step in, we can do that as well. With that, I'm going to turn it over to Logan here to walk us through this historical exploration, starting with the tensions of the Dakota Territory through the modern day establishment of the Ethics Commission. So with that, I'm going to scoot over and turn it over to Logan.
Thank you, Rebecca, and thank you, everyone, for joining us today. I'm excited to walk you through the history of ethical conflicts in North Dakota's government. So let's start with our agenda. North Dakota's history of ethical conflicts in government goes back to before it was a state. Again, today we will explore these issues and how they evolved North Dakota's laws for ethics and government. We're, of course, going to start in Dakota Territory. Then we're going to move into statehood, explore the events of the 20th century and how that shook up state government, mostly during the mid-century, and explore how these laws shaped Cold War era North Dakota in the nuclear conflict section of the presentation. And then we'll learn the current state of ethics and conflicts of interest laws in North Dakota following the oil and economic boom. Going back to Dakota Territory. Dakota Territory was established in 1861. Territorial governors were appointed by the president. The territorial government was full of controversy. A lot of this controversy is linked to control by the railroads. Former New Hampshire state legislator Amaya Ordway was appointed by President Rutherford B. Hayes as territorial governor in 1880. Here's a quick overview of what Governor Ordway is remembered for: appointing family to government offices and threatening and bribing legislators. At one point during Dakota Territory, the territorial legislature could not agree who was legally elected to the House. There were two houses meeting in two different places until the legislature could agree upon one and business could continue. But that took some time for them to agree to that one house. Moving along to the 15th Territorial Assembly, they established a 9-member commission to look at capital relocation. The current capital was in Yankton, now in President, South Dakota, and it's pictured there on the slide for you to see what our territorial capital looked like. The 9-member commission was signed into law by Governor Ordway amid accusations of log rolling, which means trading political favors, bribery, and corruption. Some historians argue Governor Ordway pushed the relocation for personal profit. Legislators supported the relocation initiative in exchange for territorial institutions in their communities. Those who supported Governor Ordway's push for relocation, he would sign their bills. But those who didn't had their bills vetoed by Governor Ordway. At the time, the Madison Sentinel described the capital relocation process as, quote, a plan where a coterie of moneyed men are to be made enormously rich at the expense of the public. According to the law, the commission was to meet in Yankton first to organize. But of course, the people of Yankton did not want the capital being moved from their community. So what did they do? They stationed themselves as guards at the edges of town to prevent the commission from meeting in town. But the commission was one step ahead of them and responded by having a 1-car train move through Yankton at 3 o'clock in the morning. They called the meeting to order on that one train car and adjourned, successfully holding the meeting right before rolling out of town. So how did Dakota Territory move forward from this? Well, it really didn't. The capital was moved from Yankton to Bismarck from the commission's work, and this move was largely due to commission member Alexander Mackenzie, pictured there on the right hand of the slide, who was a powerful political player of the time and the former sheriff of Burleigh County. Despite Burleigh County Sheriff being the only public office he ever held, his work with the Capital Relocation Commission cemented his status as the political boss of North Dakota, and he continued to have great influence over North Dakota government due to his work with the railroads. Capital relocation also resulted in a push in Southern Dakota for statehood in 1883. These Southern Dakotans were angered to learn Governor Ordway pocket vetoed a measure for a constitutional convention in Southern Dakota. Governor Ordway's story continues in 1884 when he was indicted for corrupt and criminal practice. This indictment revolved around a new county in Southern Dakota. There was an investigation into whether Governor Ordway manipulated the new county seats by taking bribes. So, let me ask you at this point, do you think Governor Ordway was convicted? A poll's going to pop up on your screen for you to vote on that issue, and we'll see if you're right. I'll give you 1 or 2 minutes to respond to that poll. Responses are still rolling in, so I'll give you a few more seconds here. So it looks like 92% of you voted no and 8% of you voted yes. So let's find out if you were correct. Well, I never got to that stage. The judge in the case dismissed it for lack of jurisdiction. Governor Ordway argued the federal grand jury had no jurisdiction over a territorial official, and the judge agreed, so the case was dismissed. But that was mostly the end of Governor Ordway's story. President Chester A. Arthur later replaced him when his term ended. At that time, a territorial congressman called Governor Ordway, quote, "one of the most corrupt and unprincipled men that has ever disgraced and degraded the public service of this country." Ordway later furthered his career by becoming a lobbyist for the Northern Pacific Railroad in Washington, D.C. So why does the history of Dakota Territory matter? Well, it influences the founding of North Dakota. Multiple attempts were made to have North and South Dakota admitted as states. Again, this was pushed by those in Southern Dakota who were tired of officials being appointed from outside the territory and who were upset by the movement of the capital from Yankton to Bismarck. But these people weren't successful until 1889. The Enabling Act of 1889 was passed by Congress. This act allowed North Dakota to become a state by holding a constitutional convention, South Dakota too. President Grover Cleveland signed the act shortly before leaving his presidential office. So, flowing from the Enabling Act of 1889, the North Dakota Constitutional Convention opened in Bismarck on July 4th, 1889, Independence Day. The draft 1889 Constitution included multiple concepts on ethical and accountable government. For example, it decentralized the power of the governor. It spread executive power among 10 other elected statewide officials. It includes the single subject rule for legislation. It also includes a provision on solicitation of bribery in the legislature. For today's purposes, we're going to be focusing on a provision on legislator conflicts of interest in Article 2, Section 43. That is the original text of that provision on the slide. And you probably can't read that given the handwriting and the scanning of the document over time. So that provision states, any member who has a personal or private interest in any measure or bill proposed or pending before the Legislative Assembly shall disclose the fact to the House of which he is a member, and shall not vote thereon without the consent of the House. This provision proves to be an essential provision well into the future of North Dakota. The voters ratified the draft constitution on October 1st, 1889, and North Dakota was admitted to the Union on November 2nd, 1889. Early leaders of North Dakota, though, had contempt for the corruption of the territorial government. And while the Constitution recognized concepts of accountable government, it doesn't eliminate unethical government. Corruption continues well into statehood, and examples include, from the 1880s to early 1900s, the continued pull of political boss Alexander Mackenzie and the influence of his Mackenzie machine and his connection to the railroads. This one's a really interesting story. In 1934, Governor William Wild Bill Langer's conviction in a money funneling scheme. This involved requiring state employees to donate parts of their salaries to the Nonpartisan League. His conviction was overturned years later, and he was acquitted during a retrial. But before it was overturned, he barricaded himself in the governor's office and declared martial law in violation of a North Dakota Supreme Court decision ordering his removal from office. After that, he later became governor again, then a United States Senator in 1941. Prior to taking his Senate seat, he was accused of receiving kickbacks, leasing government property for his personal advantage, bribery and leasing, collecting fees for fictitious services, and converting proceeds from litigation settlements. Several North Dakotans filed a protest in the U.S. Senate against Langer taking his seat and made those same allegations. The Senate responded by referring it to a Senate subcommittee that held hearings for 2 weeks. The committee questioned Langer's moral fitness to be a senator and recommended he be excluded by a majority vote. The committee's report cited the North Dakota senator for his moral turpitude as a public official and charged that he never permitted the law to stand between himself and his personal desires, ambitions, and greed. The investigation by the subcommittee revealed information concerning him tampering with the jury in his federal case, attempting to influence the federal judge, taking a bribe in favor of the railroads, and even kidnapping his own law client from a jail and transporting that client across state lines for a marriage ceremony. This was all allegedly done to prevent that client's wife from testifying in the client's murder trial. The minority report called the allegations and investigation, quote, little more than gossip and hearsay. The Senate later rejected the argument that it could refuse to seat a member by a simple majority vote, and it needed to be an expulsion of that member by 2/3. That never happened, and Langer served as a U.S. Senator until his death in 1959. Going back to 1935, shortly following Governor Langer, Governor Thomas Moody served as governor for 5 weeks before the North Dakota Supreme Court ordered he could not hold the office because he did not meet the 5-year North Dakota residency requirement in the Constitution to become governor. He registered to vote and voted in Minneapolis within the 5-year time frame, essentially making him a Minnesota resident when he said he was a North Dakota resident. In 1961, there was a bid rigging in state procurement for the governor's automobile, so it had to be a Lincoln. This helped spur the creation of the Office of Management and Budget, which was then called the Department of Accounts and Purchasing. According to an article in the Fargo Forum, early into Governor William L. Guy's first term, a bid was awarded for a new Lincoln to be the governor's automobile. Governor Guy later found out the bidding was rigged, so it had to be a Lincoln. After he received the car, he had problems with the side window closing during the winter and had it repaired at a local Ford dealership. Governor Guy received the bill, and it was so high, he wrote the president of Ford. In a few weeks, a Ford executive went to the local dealership and told the dealer to refund the money to the state. The dealer, Bob McCarney, later became Governor Guy's political opponent and ran against him for governor. But he lost to Governor Guy in the 1968 general election. Moving along to the mid-century, in 1953, during the 33rd Legislative Assembly, the legislature considers a bill titled an anti-corruption measure. The bill would have prohibited any legislator, state official, or state employee from having more than a $5,000 interest in a contract with the state. A dispute between the Nonpartisan League and the Republican Organizing Committee, then both factions of the Republican Party, broke out. The Nonpartisan League was for the measure, the ROC was against. One notable ROC member voted with the Nonpartisan League for the measure, Representative Brynhild Haugland, who is pictured on the slide and has a room at the Capitol named in her honor. They were for the measure. The ROC was against and convinced a few Nonpartisan League members to join, in opposition. But Hogland and the majority of the nonpartisan League faction opposed a motion to table the bill. The legislature ended up voting to table it 56 to 53. It would take 2/3 majority to revive the measure after it was tabled, and that didn't happen during 1953. The Noonan Miner quoted Representative Adrian McClellan of Cass County saying, "The whole purpose of this bill and the myriad of amendments is to fix it so some can serve in the legislature and others cannot. They're attempting to seek out a few members of this legislature and to disqualify them from serving." But that was not the end of the entitled anti-corruption measure. In 1954, the Nonpartisan League again pushed for the anti-corruption measure, but in a different format. This time, it was as a statutory initiative for the voters to vote on. The 1954 primary measure mirrored the 1953 bill in the legislature, but it was specific to legislators and does not include other state officials or state employees. The publicity pamphlet for the measure stated, "There is at the present time no state law prohibiting members of the state legislature from serving on a legislative appropriation committee and also receiving million-dollar contracts from the state of North Dakota. It is time that this unhealthy situation be corrected so that there will be less chance for corruption and graft in state government." The measure itself was a long measure, but the text is important, so I'm going to read that to you. It states, "No member of the Legislative Assembly of the state of North Dakota, his spouse, nor a partnership, corporation, or association in which such member or spouse has an ownership of 5% or more of the assets shall perform any work, labor, or services, or provide any material, supplies, or merchandise for the state of North Dakota or any of its subdivisions for consideration in excess of a total of $10,000 during any calendar year for such work, labor, services, material, supplies, and merchandise." Essentially, it prohibited any business that a legislator owned 5% or more of the ownership, or just the legislator, him or herself, doing business $10,000 plus with the state or its political subdivisions. A violation of this statute was a misdemeanor, and the individual had to forfeit any consideration, which is money, received in connection with the violation. The statutory initiative increased the floor to $10,000 from the $5,000 the legislature previously considered for the contract before the law would apply. And the primary voters approved it in a vote of 75,362 to 61,780. The measure was now law, but that would not be the end of the measure, especially without a fight. Following the statutory initiative's approval, Representative Clifford Lindbergh, a Jamestown legislator from what was then District 23, sued state officials on behalf of himself and others similarly situated in Lindbergh versus Benson. Representative Lindbergh alleged the law prohibiting legislators from having contracts in excess of $10,000 with the state violated both the state and the federal constitutions. Lindbergh did business with the state as a general contractor, and there were 3 parts to his dispute. First, he already had a contract with the highway commissioner and wished to complete the contract. This was easy for the court to dispose of, and they held it was not retroactive by looking at the law. The second argument was he was unsure whether the $10,000 limit applied separately for each level of government, whether he couldn't do $10,000 total with the state, a city, and a county, or if it applied to each level, so he could have $10,000 with the city, $10,000 with a different city, $10,000 with the county, and then $10,000 with the state. The court also found that was an easy argument to dispose of rather quickly in the opinion. The court held it was $10,000 per political entity. So he could do $10,000 with as many states or with as many cities as he wanted, with as many counties as he wanted, and $10,000 total with the state. So the third argument is where we need to focus today, because he argued, he was already a legislator and he wanted to continue providing services to the state $10,000 plus. But this argument required constitutional analysis. Lindbergh argued it violated both his due process and equal protection rights under both the US and North Dakota constitutions. He also argued it violated the North Dakota Constitution by imposing additional qualifications on legislators for membership in the Legislative Assembly. He had another argument that it violated the legislator conflict of interest provision that we looked at from 1889. So let me ask you, do you think Lindbergh was successful with his constitutional arguments? You're going to see another poll pop up on your screen, so let's see what you think. I'll give you about 1 more minute. You'll see some people are responding, so just wait a little bit more. Okay, I'm going to close the poll here and see the results. So 99 of you responded. 62% of you said yes, he was successful with his constitutional arguments, and 38% said no. So let's find out. The Supreme Court upheld the law in a 3-2 decision, saying it was constitutional. The Supreme Court said the purpose of the law was to extend the ancient common law rule that no state officer may be interested in any contract which he has a voice in letting by providing a more comprehensive legislative rule founded in public policy. The court went on, saying the law would take away from legislators as a class any personal incentive to increase their opportunities to make profitable contracts by their votes in the legislature, or to use their influence as legislators in securing contracts or the approval of the work done under them. By enacting this initiated measure, the people have attempted to remove from the legislators temptation to venality in the exercise of their legislative functions. The court recognized many other states had similar provisions and noted there is, quote, nothing novel either in a public opinion that the faithful discharge of a legislator's duties may be hindered by a temptation of personal profit or in the means taken to eliminate at least a part of the temptation. So let's move into the constitutional analysis. Under Representative Lindbergh's equal protection and due process argument, the court held, quote, "No individual has a legal right to be selected as a contractor for the state, and if a statute barring, excuse me, a class of individuals from an opportunity to contract with the state bears some relation to the public welfare, it does not violate the due process or equal opportunity clauses of the U.S. and state constitutions." Lindbergh also made an argument that the law violated equal protection principles because it divided contractors into two classes, according to him. The first class being those who did business with the state under $10,000, and the second class being those who did business with the state above $10,000. The court didn't agree. It held the legislation created one class, all members of the legislature. Therefore, no equal protection violation followed. Interestingly, the court commented on the $10,000 limit, saying, quote, "It was for the people in the exercise of the legislative power to decide at what particular point the size of a transaction might impair the effectiveness of a legislator's service." Moving into Lindbergh's additional qualifications for office argument, the court found, quote, "no merit for this contention. The initiated measure does not touch qualification for office at any point. It is true, one whose livelihood is derived chiefly from doing business with the state and its subdivisions may think twice before he becomes a candidate for the legislature. But the mere fact that a man cannot afford to accept an office is not in any sense a legal disqualification." And if you'll remember, Representative Lindbergh had that violation of the conflict of interest provision argument. Again, to recollect, that provision states, "Any member who has a personal or private interest in any measure or bill proposed or pending before the Legislative Assembly shall disclose the fact to the House of which he is a member, and shall not vote thereon without the consent of the House." Lindbergh made this unique argument that the Constitution provides how a legislator shall conduct himself when he has a personal or private interest in a bill. According to Lindbergh, because the Constitution directs disclosure, it expressly allows legislators to have interests in contracts. They just have to disclose them, he argued. He also argued a constitutional change was necessary to prevent legislators from having interests in contracts. The court did not buy this argument, saying, quote, "Certainly the provision contains no express grant." It also found his argument, quote, "too far-fetched to warrant serious consideration." Again, the court held in a 3-2 decision the law was constitutional. But what about the 2 in the 3-2 decision? Well, that's the dissent. The dissent would have held the statute unconstitutional and said it did create 2 classes of legislators: those who did business with the state and its subdivisions under $10,000, and those who did business with the state and its subdivisions over $10,000. It noted legislators doing business with the state obtain contracts, quote, "in the field of competitive bidding on the same basis as all other citizens." The dissent pointed out a legislator could transfer business interests to his or her spouse. They also critiqued the idea that a legislator doing $9,999 worth of business is fine, but a legislator doing $10,001 could not, saying, "This shows the unfairness and the impossibility of using a sum of money as a necessary measuring stick to determine the amount of corruption, the evil that this act is supplied to cure. Fraud, corruption, evil cannot be measured in dollars and cents." The dissent said other states include the whole class of legislators and don't divide it in 2, and pointed specifically to South Dakota. South Dakota's constitution prohibits all legislators from being interested directly or indirectly, in any contract with the state or any county that's authorized by any law passed during the legislator's term in office and 1 year after. But the dissent didn't rule the day. Again, the 3 from the decision upheld the law as constitutional. So what happens? Legislators begin resigning from office. Representative Harry A. Thompson of H.A. Thompson and Sons in Bismarck resigns. The Minot Daily News quoted him as saying the anti-corruption law made it just about impossible for him to continue in his plumbing and heating contracting business and be a member of the state legislature. Representative Thompson added his resignation was not in protest of the law, but believed he should resign and try not to get around the law. Another legislator from Grafton, Representative Ralph Adamson, resigned. Representative Adamson was involved in a large amount of school building for local political subdivision. The legislature as a whole would try to address the new law in 1955 during the 35th Legislative Assembly. There were bills to remove reference to political subdivisions, just leaving the prohibition at the state level. Legislators claimed voters didn't know what they were voting for. The law was a form of class legislation, and it was unfair. They said if voters knew what it was and voted on it again, they'd vote it down. But other legislators argued for the new law. Representative Ralph Bede of Grant and Sioux counties said, regardless of its merits, the people voted on this, and I just wonder if we want so soon to override a vote of the people by changing the terms of the law, which they themselves approved. There was another bill in 1935 to require reports on contracts with the state to the state auditor. One more would have removed the $10,000 limit and made it unlawful for legislators to do any business with the state. In 1963, during the 38th Legislative Assembly, the legislature passed a bill to repeal the anti-corruption law completely for state contracts. That required a 2/3 vote because it was a statutory initiative approved in 1954. Governor William L. Guy vetoed the bill, saying, quote, I realize this law bars many fine people from serving in our legislature. However, the law does stand as a guiding principle that North Dakotans do want to keep their legislature as free as possible from self-centered interests. After Governor Guy vetoed the bill, the legislature did not override it. In 1965, during the 39th Legislative Assembly, a bill was introduced to amend the law from $10,000 to $250,000, raising the amount of contracts people could do with the state. And it would also have raised the percentage of ownership in a business from 5% to 25%. This bill failed 31-16 in the Senate. There was also a bill to repeal the law outright again. This failed twice in the House. But that would not be the end of it. More legislators continued to resign from office, including a Minot State College professor, Representative Warren Allen. Arguments in the Minot Daily News were that the need for the law had been diminished because most state business no longer is handed out on a non-competitive spoils basis. Those newspaper arguments argued the Office of Management and Budget, which was again then the Department of Accounts and Purchases, could protect the state from corrupt practices. In 1967, during the 40th Legislative Assembly, there were Republican majorities in both chambers, but Governor Guy was still serving in office as a Democrat. Efforts to repeal again took place in the legislature. Some were critical of efforts to repeal. Representative Henry Ludin said, quote, it is easy to imagine the kind of pressure that some legislators may use in order to get a state agency or department to see that contracts move in the proper direction. But the legislature repealed the anti-corruption law over Governor Guy's veto in Senate Bill 232. Governor Guy's veto message said, quote, I believe that it could be safely said that in the present session of the legislature, there are legislators serving in open defiance of the law. The Democratic MPL party the nonpartisan league is now officially part of the Democratic Party at this time, started gathering signatures to put the anti-corruption law back on the ballot. These efforts were criticized by Representative Robert Reimers, who said, "This is the first time in the history of North Dakota that one of the two major political parties, themselves a part of the legislative process, has applied the referral to legislative action." The Democratic NPL party needed 7,000 signatures to get the issue back on the ballot. They managed to gather around 14,000. But that would not be the end of it again. A group of individuals took it back to the courts in Mellon versus Johannesson. A group of individuals sued the Attorney General and the Secretary of State in the fall of 1967. This group was made up of 2 senators, 1 representative, 1 former representative, Representative Warren Allen, the Minot State College professor, 1 citizen who voted for Representative Allen, 1 businessman who owned a company with his legislator brother-in-law, and 1 lawyer who was law partners with the state senator. The district court declared the law unconstitutional and granted an injunction to prevent the initiated measure from being back on the ballot. The Attorney General and the Secretary of State then appealed to the North Dakota Supreme Court. So let me ask you now, do you think the court declared the law constitutional or unconstitutional this time? We're going to do another poll. Give you a couple minutes to respond to this one. Give you one more minute. Okay, I'm going to close the poll now. I've been told some of you aren't able to vote. I'm not sure why that would be, but we will look into that for our next Dakota Dilemma session so we can make sure everybody can respond. So let's look at the results here. 53% of you thought it was unconstitutional this time. 47% thought it was constitutional. Okay, well, let's find out. The North Dakota Supreme Court issues its decision in July 1968. This time, it was a unanimous 5-0 decision. The court held the law classified legislators into different categories this time, like the dissent in Lindbergh suggested it did. The court held it was 2 categories of 1, those who did business with the state or its subdivisions $10,000 plus, and those who did business with the state or its subdivisions less than $10,000. The court again examined other states' anti-corruption provisions and found they did not include a dollar amount. The court disagreed with the Lindbergh majority court that size determined the evil. Instead, the court said, the evil is that a legislator might permit his vote to be influenced by personal interests. Its index is the existence of the personal interest, not the amount of money involved. It appears the court would have upheld the law if it prohibited any contracts with the state or its subdivisions among legislators. The problem, it appears, was the dollar amount and the percentage of ownership in businesses for legislators. The court said the classification system was a denial of one's equal protection rights. It found the stockholder provision, the 5% provision, denied equal protection even more than the $10,000 limit. The court referred readers of its opinion to the conflict of interest provisions in federal law, saying, conflict of interest legislation involves much more than the mere prohibition of doing business with the state or its subdivisions. The court critiqued the process of the Department of Accounts and Purchasing, saying the bidding process required by administrative practice for more lasting public protection should be required by law. The court said, although the law is unconstitutional, there still exists a constitutional safeguard in Section 43 of the North Dakota Constitution. Here, the court was referencing the legislator conflicts of interest provision in existence since 1889. It said it was intended by its framers to prohibit a legislator from voting on any bill proposed or pending before the Legislative Assembly if he has a personal or private interest in it, unless authorized to do so by other members of his House. The court said if that provision was not being enforced, it is certain that it could be enforced under the power of each House of the legislature to judge the qualification of its own members. After Mellon, the North Dakota had to rely on the constitutional conflict of interest provision for legislator conflicts, as no statutory equivalent existed because of the court's decision. But that didn't stop the legislature from passing bills on the issue. In 1973, the 43rd Legislative Assembly revises the Criminal Code in Senate Bill 2045. This was a substantial revision to the criminal code that existed before then. State law now prohibits public servants from speculating or wagering on official action or information in North Dakota Century Code Section 12.1-13-02, or taking interests in public contracts in North Dakota Century Code Section 12.1-13-03. Moving along into the 1980s, the 1981 legislature amended its conflict of interest rule, which previously mirrored the constitutional provision from 1889. That 1981 legislature added a sentence defining personal or private interests as, quote, an interest that affects the member directly, individually, uniquely, and substantially. According to legislative history research, this was added because committee members expressed concern over confusion among legislators related to instances when a conflict should be disclosed. Members expressed the opinion that there is a difference between a specific conflict of interest as compared to a remote conflict because a legislator is a member of a larger group. All four pieces of directly, individually, uniquely, and substantially had to be met for a matter to be personal or private interest requiring disclosure. The legislature, quote, interceded that this language serve as a guideline for individual legislators in deciding whether to disclose an interest in a measure. During the 1983 legislative session, House Concurrent Resolution 3029 is approved to put a constitutional measure on the 1984 general election ballot. This resolution included a repeal of the legislator conflict of interest provision in the state constitution. It was part of a larger package of changes to the state constitution. The intent behind the measure was the Legislative Assembly thought it was better handled by its own rules, and the voters agreed. They approved it as Measure 2 during the 1984 general election. Therefore, the conflict of interest provision was removed from the state constitution. But the legislature in 1987 indicated its continued support for the legislator conflict of interest provision in its own rules, and it continues to exist in the legislature's rules today. There was also continued support by the legislature to have it in its rules in 2023. During our most recent legislative session, the legislature made a new statute, North Dakota Century Code Section 54-66-18, which requires the Legislative Assembly to adopt conflict of interest rules. Moving into the 21st century, there were more legislative efforts. In 2005, Senate Bill 2303 included a provision that would have created prohibitions on gifts from lobbyists to legislators. In 2011, in House Bill 1298, this would have created a state ethics committee. In 2013, in House Bill 1442, that bill would have created an independent ethics commission. And then in 2015, House Concurrent Resolution 3060 was proposed, which would have added a constitutional amendment creating an independent ethics commission. While those provisions did not move forward, we move into 2018, and the issue is put back on the ballot. There was a citizen-initiated ballot measure sponsored by North Dakotans for Public Integrity that put Measure 1 on the 2018 general election ballot. Measure 1 establishes a state ethics commission in the North Dakota Constitution. The voters in 2018 passed the measure by a percentage of 54 to 46%, and it created Article 14 of the North Dakota Constitution. North Dakota now joins 47 other states with an independent ethics commission, or its equivalent. Only 2 states don't have a government office dealing with ethics, Idaho and Wyoming. Information materials and newspapers at the time of Measure 1 specifically referenced the commission undertaking the issue of conflicts of interest across state government. In 2019, during the 66th Legislative Assembly, the legislature passes enabling legislation for the commission that sets out procedures for the commission and certain penalties the Constitution required the legislature to create. This includes penalties for lobbyist gifts, lobbying by public officials, and lobbyists delivering campaign contributions. Also in 2019, the commission had its first members appointed. The Constitution requires 5 members appointed by the consensus agreement, so they all have to agree, of the governor, the Senate Majority Leader, and the Senate Minority Leader. Commissioners cannot be lobbyists or other state public officials when they're appointed to the commission. All of our current commissioners are the original 5 and have been reappointed for second terms. They include Chair Paul Richard of Fargo, Vice Chair Dave Anderson of Bismarck, Ron Goodman from Oaks, Dr. Cynthia Lindquist of St. Michael, and Ward Kosher of Williston. The mission of the North Dakota Ethics Commission is to strengthen the confidence of the citizens of North Dakota and their government by ensuring and promoting transparency and accountability. So what does the Ethics Commission do? Well, the Ethics Commission has authority to adopt ethics rules related to transparency, corruption, elections, and lobbying, to which any lobbyist, public official, or candidate for public office shall be subject. And it also has the constitutional directive to investigate alleged violations of the Commission's rules, Article 14 of the state constitution, and related state laws. The Commission has exercised its authority and has established rules related to the complaint process, lobbyist gifts, the appearance of bias in quasi-judicial proceedings, and conflicts of interest. The conflict of interest rules apply to all state public officials, not just legislators, and walks them through the process of how to manage potential conflicts of interest when they come up in their work in our state government. The Ethics Commission continues to work with entities our rules impact to ensure understanding and uniformity. And the Commission is currently discussing financial and travel disclosure statement rules for public officials. At our next webinar, Dakota Dilemmas, a practical application of conflict rules, on March 28th, again at 12 o'clock noon, we will be discussing how to apply the Ethics Commission's conflict of interest rules and how to work through that process. So I hope you will sign up and join us again as we teach you how to walk through the process of disclosing a conflict of interest when it comes up. I'd also like to thank Legislative Council today for providing legislative history information, Nancy Guy for providing some historical information for this presentation, and Mary Stewart from the North Dakota Monitor for additional research for news articles she has published on this issue that she shared with us. So let me ask you the question. Were you surprised by anything you learned today? I got another poll for you and it's gonna pop up on your screen. So vote if you can, and I'd like to see what you think. I'm going to give you a little more time to respond to that poll, but while you're responding to my question, I want to ask you if you have any questions. So if you have any, drop them in the chat and Rebecca will be monitoring them and asking us what they are and seeing if we have a response. So go ahead and ask us whatever you want. Yeah, I'm going to close the poll and then we'll turn to your questions. So it looks like the majority of you were somewhat surprised by stuff you learned today. So good to hear. Some extremely and some very little. So thank you for responding. I think Rebecca's monitoring the chat, so we have some questions we'll address here.
So the first question that we got, we're going to hop, both of us, we're going to dual screen this here. The first question we got is that whether this recording of the webinar today will be available to share with others. And the answer to that, I will kick the rest of them over to Logan, but I will go ahead and answer that one that yes, it will be. If you want it to be emailed to you directly, if you've registered for today, we can go ahead and do that shortly. But it will be publicly available soon as well. I don't have an exact timeline on that, but it will be shortly. The other question that we're getting is kind of some more practical questions about the Ethics Commission. And I'm going to ask the question as if I was the person in the chat, and I'll send it over to Logan. So how about, Logan, can you tell us where the Ethics Commission is located?
Absolutely. So we're in the state capitol building. third floor of the judicial wing. So we share this floor with the Department of Human Services, but you can come find us, get off the elevators and take a right. And we're here in the judicial wing.
Through the very large black doors.
Yes, you have to walk through some black doors, but then you should be able to find us.
So just to clarify, the Ethics Commission, there is a provision in a state statute that says the Ethics Commission has to have a separate office with separate entrances than any other state agency to keep or remain independent. So that is what we have. The commission used to be located off-site of the Capitol when space in the Capitol was quite restricted and there just wasn't a lot of room. And so now we do have some space thanks to some reorganization and work from home possibilities. So Logan, could you talk just briefly about how one becomes a commissioner on the Ethics Commission and what that looks like?
Sure. So there'll be a call for applications when there's a vacancy on the commission, and that's all submitted through the governor's office. So people can go online and submit their application. And then it's up to 3 people, the governor, the Senate Majority Leader, and the Senate Minority Leader, to actually appoint our ethics commissioners. So the 3 of them will meet and go through those applications. I believe there's an interview component to the process now as well, but we're not privy to the whole process because we don't make the appointments at the Ethics Commission. So they will come in, they will interview, and then they will make their decision. But during that decision, all 3 of those individuals have to agree on the people that get appointed to the Ethics Commission. And I've never been in that process, but I'm sure it takes some work to get 3 people to agree, especially when you have people across the political aisle that have to agree on who they will put on the commission.
Yeah. The next question, and I'm kind of jumping around, so I apologize. I'll get to some of the ones that were initially asked, but I'm going to jump to this question about advisory opinions. So the Ethics Commission does issue advisory opinions. So Logan, could you maybe share with us a little bit about the effect of an advisory opinion? Maybe who can request an advisory opinion and what that process looks like. There's a specific reference to whether it's similar to an AG open records, open meeting opinion request, or maybe perhaps it's more akin to something else.
Sure. So in 2021, I believe, the Legislative Assembly passed a statute that allows the Ethics Commission to create advisory opinions. So for an advisory opinion, the commission needs a request from a public official, I believe a candidate for office, or a lobbyist on prospective conduct. There's another component that's not coming directly to mind right now, but on prospective conduct applicable to that individual. So the commission will consider that information. The requester's name is an exempt record. So if you are requesting an opinion, the chair and the executive director, they have the delegated authority to determine if your name as the requester will be an open or closed record. But the substance of the opinion will be provided, and that lays out how somebody should act according to that fact pattern. So if the public official, candidate for office, or lobbyist acts in accordance with what they requested an advisory opinion on, the facts have to be similar, they have to act in accordance with the advisory opinion, then they're basically immune from an ethical violation or a criminal violation if it would apply, as long as they're acting in accordance with what the commission advised.
So it's more akin to a request to regarding attorney conduct, attorney ethical conduct, than it is to an AG open opinion or open record, open meetings request.
Correct.
Okay, very helpful. All right, one of the other questions that we got is, hey, Logan, can you go back and review and just remind everybody over whom does the Ethics Commission have, the fun word I use, jurisdiction? So maybe let's talk about that just a little bit in general. There was a lot of discussion in the history about that focused on legislators, right? Because there was that legislative conduct, but that is not what the Ethics Commission is limited to.
No,
So let's talk about that.
the Ethics Commission has more authority over individuals. So the constitutional language says public officials, candidates for office, and lobbyists. I believe I'm not missing anything.
I think it's political committees maybe
Political
is way.
committees might be
There's a
in there.
few other
Yeah,
ones.
but
The big
specific to state officials, public officials includes elected or appointed officials of the executive branch. It does not include just executive branch employees, but public officials does include legislative employees. So you have that little
difference.
yeah, that little niche into the language there that applies to legislative employees, but not executive branch employees. So there is some distinction there that you have to dive into the language to figure out exactly who is covered by the Ethics Commission. But then we also have authority over lobbyists and candidates for office and political committees.
So when we talk about individuals who are appointed,
Mhm.
so for instance, I get to serve as executive director, I'm appointed. Who are some other individuals who are appointed? Is it just state employees, full-time state employees, or does it include anybody else?
Sure. So the biggest group of those individuals are going to be people appointed to boards and commissions across state government. You also have, for example, the members of the governor's cabinet. They are all appointed. Some employees in executive branch offices are appointed too. So it gets very nuanced once you get into that employee level if somebody's appointed, because then they're actually considered a public official.
So there's also other constitutional language that talks about even another group of individuals that gets covered that isn't necessarily appointed or elected. Is that correct?
Yes, that would be in the quasi-judicial provision of Article 14. So when somebody comes before the state in a quasi-judicial proceeding, which is basically a baby court proceeding, I guess, in an executive agency, that's a quasi-judicial proceeding. Those individuals, there's like 5 terms our Constitution uses: heads, executives, directors. There's a few more that I'm not
Maybe one more, but
missing, but those people also come under the quasi-judicial jurisdiction of the Ethics Commission. So if you're involved in those proceedings and you think you're just a state employee, you probably want to be careful to make sure that you don't fall under that distinct provision, separate from our conflict of interest and gift rules and everything else.
yeah. Okay. I'm gonna review the chat one more time. And we've got a few that I think I will answer. Early on, there was a question about training for legislators. And so there is required ethical training currently for state legislators. The Ethics Commission has not been part of that in the past. However, the Ethics Commission has provided training specifically to legislators. We started that last legislative session, and we're going to continue to do that. I envision in the future that we'll work with legislative council and legislative leadership to continue that education and make sure that we do things like today where we're doing a webinar. Now this is very particular, not very particular, and you know, kind of a general overview. This historical perspective is really the start of our educational information, and so we do continue to continue that with legislative council. Another question that came in was about Ethics Commission funding and how the Ethics Commission has been funded. So while the Ethics Commission is not part of the executive branch, the legislative branch, or the judicial branch of the government, it is a constitutional entity. But the funding for that is done through the legislative process, just like funding is for any other agency, branch, or governmental entity. And so the legislature provides funding for the Ethics Commission. When the legislature was first funding the Ethics Commission, because it's so new, the first time they addressed this was in 2019. and they really didn't know where to start. It's difficult when you have never done anything before. And so they went ahead, they found a number, and then they started there. What we've learned over the last few years is that that number has been insufficient, in the sense that the Ethics Commission had a deficiency request to the legislature last year. The legislature responded positively to that and provided those funds. And then during the last legislative session, I use the term right sizing. I know others may not love that term, but we worked to right size the budget for the Ethics Commission during legislative session. And so we went ahead and we did that. Giving due consideration to the fact that where we started didn't have a factual or a great basis, because it was kind of a guess to see what was going to happen. And so we're going to continue to evaluate that funding as we move forward. But there is also a constitutional provision that the legislature is required to adequately fund the Ethics Commission. So what that looks like is gonna vary, and that's going to be a continuing thing that changes in the future. So I'm going to quick hop on to other messages or questions here. Logan, one of the questions that's not in the chat that I had is, or that others had, is we talked about who serves on the Ethics Commission, but are they full-time employees? How often do they meet? How do I get access to their information? Can you tell us a little bit about that?
Sure. So we start with our 5 commissioners. They are not full-time employees. They serve for our regularly scheduled monthly meetings. They will attend those, and sometimes we do have special meetings, give or take one a month. So they will serve for those, but the commission does have 3 full-time staff members, including Rebecca as the executive director, myself as general counsel, and then we have our operations administrator, Alicia Meyer, who's probably on here lurking somewhere as a participant. So we serve full-time as their employees.
Okay, and how can I attend their meetings?
Sure. So most of our meetings are online in this Teams format. So you can go to our website and find our agendas, and that should have the link if you would like to attend and watch our meetings. So you can attend those monthly. We do try to meet in person, or we will try to meet in person at some point this year. So just watch out and watch our agenda for that if you'd like to come.
Is there any place else that they could learn more about those kinds of things?
Absolutely. So the commission just established a Facebook page, so go give that a follow. You can find that on our website. So ethicscommission.nd.gov, which also has a bunch of information about the commission. And then we're also available anytime if you want to talk to staff and get more information. Our contact information is on the slide there with our email and phone number. So if you have questions, just reach out and we'd be happy to respond to you.
So there's one other question about whether you can remind us of not the individuals the Ethics Commission oversees, but the subject matter, or what issues the Ethics Commission can investigate. And then I'm going to ask a follow-up question about that investigation to clarify something.
Sure. So the Ethics Commission has authority over transparency, corruption, elections, and lobbying, according to Article 14 of the North Dakota Constitution. Now, those areas are pretty broad, so the commission is in the process of figuring out what its rules should look like to cover those 4 areas and how to go forward with that process. And then it has the authority to investigate alleged violations of those rules, Article 14, and related state laws. So it's not just defined by the commission's rules when it comes to that investigation.
Okay, so how does the Ethics Commission decide to investigate something?
Sure.
Can you talk about that process at all?
Sure. So in 2019, the legislature passed a statute that requires the commission to have a complaint before an investigation can be initiated against a public official or a lobbyist or whoever under our jurisdiction. So the commission needs to receive a complaint before it can initiate that investigation.
And then is there anything unique about that investigation process or the complaint process?
Sure, I'm sure we'll be doing a webinar on this in the future.
We will.
But in short,
Making a plug for it.
there's 3 parts to an ethics complaint investigation. So we start with the initial review. Is this alleged conduct the commission has authority over? And is it a person the commission has authority over? So the executive director will do that initial review. And if one of those 2 things are not met, the executive director has the authority under the statute to summarily dismiss a complaint. But if that complaint is not summarily dismissed during the initial review, it moves into the informal resolution process. So both the complainant, the person who files the complaint, and the respondent, the person who the complaint is filed against, have a chance to see what they want out of this process. What is it something you could agree on to resolve the complaint? So if they resolve it, it does not move forward. But they have to agree to that during that process to the complaint. If they do not agree or they do not want to do the informal resolution process, then the investigation starts where the commission will start to look into the allegations and see if they are substantiated by the evidence that it finds. And then after that, it goes to a report that goes to the full commission. And then the person who the complaint is filed against has an opportunity to respond in person or in writing.
All right, Logan, we just got one other question. I'll look at it. I saw it pop up, but I have a question for you. I'm going to put you on the spot maybe a little bit. What was the most interesting thing that you learned during your research for this presentation?
Sure. So I really like that story about the Lincoln automobile and how that helps for the Office of Management and Budget and our procurement practices in the state. I also think the Dakota Territory stuff is extremely interesting, just how the citizens banded together during capital relocation in Yankton and didn't want it to be moved to Bismarck, but we won. So here we are in the capital in Bismarck.
Here we are in the capital in Bismarck. So there was a question about in the Teams meeting in the chat, and I'm going to go to it again about when rules require notice that be provided to the commission in some circumstances. For instance, when there's food and beverage served for immediate consumption at a private or public social and educational event. Who do those go to? Who gets those? Do you send them to me? Do you send them to Logan? So the Ethics Commission has a general info email address that you can send correspondence to. And that email is ethicscommission@nd.gov, which is up on your screen right now, I believe, right?
Yes.
Yeah. So you can go ahead and send those to that. If you ever have any questions, you can reach out to myself and to Logan. And we can gladly answer those questions ahead of time so we don't have issues down the line. So I learned so many interesting things about the state of North Dakota during this presentation today, and I really appreciate all of the work that you put in. So with that, I'm going to do one last check of the chat, folks, to see if there's anything else. Any other questions? I'll give you just a minute to get those in. And we want to make sure, put another plug in for our next webinar, which is 2 weeks from today. We'll go back to it. You will also learn that we are going to be doing more of these throughout the year on specific topics to help you walk through them, learn more about them, whatever it may be. If you have ideas for webinars, also shoot those our way as well. With that, oh, is this approved for NDCLE ethics credit?
Yes, it has been approved, and we will work on submitting that list to SBAN. So that should be added for you.
So if you are registered, you came today, attended, we will submit that on behalf of them, right? Yep. Great question to wrap up our presentation today. All right. With that, we will sign off. Thank you, everybody, for attending, and we look forward to many more of these.
Thank you, everyone.